Hey, it's my pleasure to reintroduce Chris Sallay, who's going to talk to you about motion practice from the plaintiff's perspective. I already spoke about it from my talk from the defense, so Chris is going to give a little bit more of a substantive discussion from the plaintiff's side. Again, it's my pleasure, Chris Sallay.
Thank you, Robert. Summary judgments from the plaintiff's perspective. In auto cases, plaintiff oftentimes, except in like the hit and rear cases, are defending the summary judgment motions. But if you read the case law and follow it, and you have the right case, you can make them in other cases besides just hit and rear cases. And it's something I think attorneys need to really consider and really look at and just think from the very beginning of the case, is this a case where I can win summary judgment? Is this a case where I want to win summary judgment? And as a plaintiff, prepare your case with that in mind as being a potential option should you choose to go down that road. If you don't think about it from the beginning, though, when it comes time when you want to make the motion, it may be already too late. Like, for example, when I said about getting the affidavits from the witnesses as opposed to simple witness statements, good scene photographs, things of that nature, having your experts visit the scene and do accident reconstruction. If you don't do that stuff at the beginning of the case, and then the road changes, the vehicles disappear, the witnesses, all of a sudden they fled the country or they disappear or their memories are fading. If you don't do it at the beginning of the case, you'll be forever precluded from doing it. This goes for plaintiff and defendants, quite honestly, but really from the plaintiff's perspective, you'll be forever precluded from doing it when you really need to do it or want to do it. Now, before I get into the reasons why you want to do it and what you want to do in terms of preparing for it and making the actual motion, you've got to know a bit about the rules regarding summary judgment. Okay? CPLR 3212, you have 120 days to make a motion following the filing of a note of issue. Well, PC orders and certain judges shorten that time. They shorten it to anywhere from 60 to 30 days, and they will not entertain a motion because they put it in their rules, and I'm sure someone here has heard it. Counsel, can't you read? Did you see it in my PC order that you signed that you had 30 days following the filing of the note of issue to make a motion for summary judgment? You didn't. I'm not hearing that motion. So know the rules of the part you're in. As far as your timing is concerned, the part can modify the rules, making the 120 days a lot shorter, but they can't extend it, except on good cause shown. That's right in the statute. Okay? The other thing that part rules that you have to be aware of is the format of the papers. There are judges, and I can name two off the top of my head, but I know there's more, especially in Manhattan, that require summary judgment motions to be formatted a certain way. What do I mean by that? They want it to almost look like a Supreme Court or a federal court brief. Separate bindings, exhibits labeled separately, tabs separately, bound at the edges, and guess what? You'll either get a nasty letter, a nasty phone call, or an outright rejection of the motion, and then by that time it might be untimely to remake the motion from those judges if it's not properly formatted. Okay? Very important to know the part rules, because some of these judges, they have very finicky, specific ways they want their papers to read. I don't know if it makes life easier for them, or they just like to have these, rules, quite honestly. All right, but that's something to be very much aware of. Now, I want to tell a quick story as to what I mean when I say not just in rear-end collision cases. A year and a half ago, I am at a mediation with an attorney, and it's going very long. It's a heavy-duty construction accident products liability case. We're in Brooklyn before Judge Schmidt. It gets to be late at night. We move to a court reporting agency. We continue the mediation until about 8, 9 o'clock at the court reporting agency across the street. I live in northern Westchester. He lives in southern Westchester. After we're done, the case settles. I say to him, hey, you know what? I'm taking a car service home. I'm not going to take the train. You want a ride? I'll give you a ride. I'll drop you off at your house. Sure, why not? Gets in the car with me, the black car, and we drive up and we drop him off at his house as the livery driver pulls into the gentleman's driveway, parks behind the attorney's wife's SUV. Okay? This attorney gets out of the car on the passenger side from the rear seat, walks around the front of the livery car, in between the front of the livery car and the back of his wife's SUV. I scoot over in the seat. If I was sitting behind the driver, I scoot over to sit more behind the passenger side. The delivery driver turns to look over his shoulder to back up. Car is still in first gear. It's still in forward. Steps on the gas, and I have no idea how the attorney jumped out of the way in time, landed on the hood, and didn't have both his legs crushed. All right, he's going to be speaking after me. His name is Brian Stapleton. His story's a lot funnier when he's sitting here and I tell it, because he's a true story. But he's going to be speaking about it. That's a case where if, in fact, he was injured, and thank God he wasn't, that's a case where summary judgment would be appropriate for the plaintiff. Okay, and that's one where people don't often think about making a motion, and they should. All right? Now, there are times when you're going to want to make a motion, and there's times you're not. Depends on what type of case it is, what's involved. For example, you may not want to make a motion for summary judgment if there's alcohol involved from the defendant driver as a plaintiff. Why not? There could be a punitive aspect to an award where there's alcohol involved with the defendant driver. Now, those of you who are saying, well, wait, Chris, you can't get punitive damages. I'm not talking about punitive damages. I'm talking about a punitive compensation award. The jury gets so angry and so annoyed at the conduct of the defendant that they give the plaintiff a higher award. And if you don't think that happens, you're being naive. It happens all the time. A lot of times, it's based on whether they like someone or not, if someone is a jerk or not. Okay? It's important. In a case where there's alcohol involved, or texting while driving has become a very familiar area in the last few years. I think I read a study where it said they were 8 times more likely to award a higher amount if the person was texting while driving and caused the accident. I mean, it's just crazy. So in those circumstances, you may not want to make the motion because you may want the jury to hear that. You may want the jury to hear that to help with the damages award. Now, from a defense attorney's perspective, if you want to concede liability in a case where your defendant has alcohol or is texting and is responsible for the accident, strategically may be a good move, because the jury then will never hear that the defendant had a quart of tequila in them or whatever it is, okay, was texting while driving. All right, so that's something, but as a plaintiff, when you're thinking about making that motion for summary judgment, be aware of that. It's not for every case. Now, the other thing you want to consider when you're thinking about making this motion, this goes for plaintiff and defendant, the judge you're in front of. Is the judge going to read the papers? Okay? Anyone here ever argue a motion where the judge never read the papers? You walk up and say, hey, what's this case about? I'm the only one? No, other people have. Okay. I didn't think I was the only one who ever had that experience. Know the judge. If it's a case that you can summarize in like 2 seconds as a plaintiff, as far as the liability is concerned, judge, left turn, defendant turned right in front of my client. Client didn't have a chance to stop. Defendant never saw my client. Boom. All right? You have a case that sounds like a summary judgment case to a judge who is not going to be maybe as attentive in reading the papers as he or she should be. Okay? Know your judge. Are they inclined to grant the motion? Are they the kind of judge who doesn't like being reversed or doesn't like granting these motions? Think about it. Now, anyone here know Judge Schmidt in Brooklyn? Anyone ever been in front of him? All right. Judge Schmidt in Brooklyn is one of my favorite judges. For those of you who don't know him, he has on his table, when you argue the motions for summary judgment, cars, trucks, buses, models of every kind of vehicle you can think of. He will say to you in his voice, come here, show me how the accident happened, use my cars. And if it's a school bus, and he has a school bus. And you do it with this, and you better know that, first of all, going in, but more importantly, as a plaintiff or as a defendant, if you can show how the accident happened in a way that blames the other side completely using his models, he's going to love you. He'll write his little Post-it notes. He's got a stack of Post-it notes about this high, and he writes everything on Post-it notes, and I don't know how he finds them afterwards, but he always writes a rational decision based on his Post-it notes. But if you can explain a summary judgment motion with his vehicles in a very accurate and precise and logical manner, you have a good chance of winning summary judgment in that case, because he's going to rely on that. That's what he's going to have as his impression. Okay? Something to be considering, knowing your judge. Now, why would you want to make a motion for summary judgment, assuming you have the right type of case? Well, you're strengthening your positioning, your bargaining on the case if you win. If the defendant knows that they can't defend liability anymore, they can't even get a 5% or 10% or have the threat of a defense verdict hanging over their head, and especially in some counties like Westchester or Nassau, Suffolk, some Staten Island, some of the more conservative counties. And if it's just going to be damages only, and you can argue to a jury, ladies and gentlemen, liability has already been established. It's already been found as a matter of law the defendant is 100% responsible for this accident. That's a very powerful argument to make, and it improves the bargaining and strengthens your position and makes the case more valuable. The other thing it does, it starts the interest clock ticking. People don't always realize this. It's 9% interest on whatever damage award there is from the time of the entry of the judgment, on summary judgment. So if the case is in Bronx, for example, anyone here file a note of issue, and in the Bronx they get a trial, the next month, 2 months, right? 2 months, 3 months? It's about a year and a half before you get a trial in the Bronx. If I can have liability established and I'm sitting on the calendar earning 9% interest for a year and a half, I've just added significant value potentially to my case as a plaintiff. And that's why I would do it in that situation, okay? That's very important to keep in mind. Now, what materials are you going to be using when you're making the motion for summary judgment? This for plaintiff and defendant. It has to be admissible form. Some people don't even consider this. They will attach a police report as a motion, as an exhibit. Now, part of the police report may be admissible for the date, the time, the place of the occurrence, the TPO that you see on the police report. But if you're using the police report to say, well, the police found that the defendant ran a red light, well, unless the officer witnessed that, that's hearsay, that's inadmissible, okay? Unless it says the defendant driver said, I ran a red light. Well, that's different. That's a party statement, that's a party admission. That may or may not be admissible depending if it's properly sworn and certified. All right? Another thing, deposition transcripts. Those should be definitely part of any exhibit, but you often, of any part of any motion, excuse me, but the depositions have to be done, as Tony said, and you can tell probably that I was trained by him to a large degree, it has to be done the right way. It has to be done where that you can point to one or the other or both of the transcripts and have the whole story. There's no gaps, okay? And one other thing I should mention a little earlier, the timing of it. You always make your summary judgment motions after you file your note of issues, almost as a rule. Because if you don't, I can guarantee you whether there's anything out there or not, you're going to be hit with an opposition that says discovery's not complete, we need additional discovery. Now, there's some case law which says unless the additional discovery can be reasonably shown to have an impact on the decision, otherwise it's not to be, that's not a valid defense. Most judges will say, I'm not going to decide the motion until after all discovery is complete, and they will just basically table the motion. So wait until after the note of issue is filed before you do it as a general rule. Okay. Now, when you're doing the motion, one of the things you want to do when you have the defendants, especially from the plaintiff's perspective, if you're making this motion, you attach the defendant deposition, the plaintiff's deposition, you're trying to force the defendant sometimes to sign an affidavit that has to contradict their deposition. As a defense attorney, if you can avoid this at all costs, do. Because all you're doing now is setting up your client as either a liar, have a bad memory, or be very inconsistent, and it necessarily won't always win you that motion. So it's something to think very hard about if you want to have your client sign an affidavit that says something contrary, or even can be interpreted as contrary to the deposition. You might have just given the plaintiff a very, very big piece of ammunition for later on down the road. Now, by the same token, an affirmation by itself from an attorney, not evidentiary. It's not enough. You have to point to some specific proof. If the plaintiff attached the deposition transcripts, you can use those and point to the inconsistencies and try to make your argument based on that. Or based on, if there's photos that can be, viewed and interpreted a certain way, that there was an obstruction somehow and it was consistent with the testimony. That's how you can defeat those motions. Alleging, culpable conduct, I'm going to get into that in a moment, as a jury question is not always enough unless you can point to some specific proof that a judge or jury can infer there was culpable conduct. In hit and rear cases, that's almost an impossible burden. If the car is stopped and the client strikes, and your client strikes the stopped vehicle, you're going to lose that motion. The plaintiff is going to win that motion because what's the culpable conduct? Now, the seatbelt defense is not a defense to a liability motion. The seatbelt defense, and it says it right in the statute, the seatbelt defense is a mitigation of damages defense. Section 1229C of Vehicle and Traffic Law, and it's a very specific section. And I'm going to read it because you hear the language, you're going to say, oh, yeah, there's a lot to prove here. Non-compliance with the provisions of this section, requiring operators and passengers to wear safety belts, shall not be admissible as evidence in any civil action in a court of law in regard to the issue of liability, but may be introduced into evidence in mitigation of damages, provided the party introducing said evidence has pleaded such noncompliance as an affirmative defense. So if the plaintiff makes a motion for summary judgment and you oppose the motion saying the plaintiff wasn't wearing a seatbelt, well, that's not good. The judge is not even going to consider that. They shouldn't consider that in determining liability. It's not even a defense for comparative negligence. It's only a defense on mitigation of damages. And if it's done right, it can be a very powerful defense. It can be a very successful defense. But I've seen it too often where an attorney will say, well, it's a question of fact as to whether the plaintiff was wearing a seatbelt in opposition to a motion for summary judgment. That's not going to win the motion. That's not going to get the motion defeated. Now, the types of motions that you're going to be considering making is, of course, the rear end collision. Okay? Unless you have an exceptional circumstance type case, as a plaintiff, you're almost always going to be making a motion in a rear end collision case. My office has them as a form. The case law is pretty clear on this, and it's a VTL violation, following too closely. All the language that you're going to start seeing permeating the cases, it's all in the hit and the rear cases, the rear end collision cases. You're going to make that motion, and you're going to win that motion almost every single time. If you want to try to argue that they got cut off or stopped short or things like that, most of the time the court's just going to flat out reject that argument. Okay? And then you're going to start seeing in the rear end collision cases as a nice jumping off point is the language. I'm going to call it the magic language. There's really 2 or 3 key phrases that permeate all the automobile litigation summary judgment motions and all the judges' languages in that regard. He should have seen what there was to be seen. That's one. You're going to use that language, and when you're taking a deposition of a client, of anyone for that matter, I often see at the deposition, and I love when they say this, I love when any witness says this, when did you first observe the other vehicle that you later came to be involved in an accident with? I didn't see them until right before the accident. Was there anything obstructing your view? No. Any poor lighting? No. Any distractions? No. Could you tell me why you didn't see them? At that point, you can see where that's going. The courts have said, and it's right in the pattern jury instructions and right in the vehicle and traffic law, a driver or pedestrian, this applies for plaintiff and defendant, and it can be used by defendants in opposing these motions as well, has a duty to see what there is to be seen, and the courts have gone even further. Testimony that they did not observe the plaintiff, the defendant, prior to the accident, although there was no obstructions, is going to be incredible as a matter of law. In other words, people don't just pop up out of nowhere. They don't just spring from the ground or drop from the sky. Okay? It's very important, that language, and you're going to see that permeate throughout the case law. Excuse me. The other language that you're going to see permeating the case law, there's going to be a couple more, is a driver has a duty to has the right to anticipate that another driver will obey the rules of the road. Now, what does that mean? That means when I'm driving down, what's this, Old Wall Whitman Road out here? When I'm driving down this road, I have the right to expect that a car is not going to come across the double yellow line going in the opposite direction and strike me. I have a right to expect that. If I didn't have the right to expect that, think about it, common sense, it would be chaos on the roads. Everyone is expected to obey the rules of the road. And people traveling have the right to expect other people are going to know the rules of the road and obey them. Now, that language also permeates the case law, especially in the area of pedestrian knockdowns in crosswalks. Now, I want to talk about a case involving a summary judgment motion in a pedestrian knockdown in a crosswalk. And the case is called Kurtzgassner. Now, it's 836 New York sub-second 170. It's a First Department case in 2007. Kurtzgassner is a pedestrian knockdown. Kurtzgassner, Mrs. Kurtzgassner was crossing 6th Avenue at 55th Street. She had the walk signal. There were two eyewitnesses. She's crossing, going in this direction. A delivery truck is coming over her left shoulder, makes a right-hand turn. The truck, it's a 6-lane road at that intersection, 6 lanes across. The truck then decides he's got to be in the right lane, in other words, the lane closest to where she exited the curb, because he wants to make a right turn at the next street, which I guess is 54th Street. Okay? He veers his truck into the crosswalk. The middle of his truck knocks her down, and the rear wheels run over her and kill her. Okay? Now, there were two eyewitnesses to this. Now, this case is significant for a few reasons. Number one, summary judgment was granted by the trial court in the Bronx on liability, no comparative, based on large part on the eyewitness testimony. Eyewitnesses corroborated the story 100%. Obviously, Ms. Kurtzgassner wasn't around to corroborate the story, so it had to be proven through the eyewitnesses and through the driver of the vehicle. All right? That's number one. It went up on appeal. The defendants had accident reconstruction and biomechanical experts who prepared analyses and affidavits to try to defeat this motion. Just as an aside, Ms. Kurtzgassner was a well-known bond trader who was earning several $1 million a year. Okay, and it was a wrongful death case. She also had a 9-month-old son. All right? So the value and the exposure in this case was astronomical. So the defendants did what they had to do, at least in their minds, to try to somehow mitigate damages, lessen their potential exposure. So they hired accident reconstruction experts. They submitted affidavits based on their analysis that says Ms. Kurtzgassner walked into the side of the truck and was partly to blame for the accident. The First Department, in language it's very telling, basically said uncontradicted eyewitness testimony established the liability in this case. The defendant's speculative expert assertions were not going to be enough to overcome a clear VTL violation. Just because you may say it, that this is what happened, these eyewitnesses, and there were two of them, who said this is what really happened, just because you hire an expert who says something else, even if it sounds scientifically plausible, accurate, is not going to be enough. Anyone here ever heard the term swag? Anyone know what swag is? It stands for, a scientific wild-ass guess. Okay? When you have experts who issue swag opinions, conclusory opinions that sound scientifically sound but are really based on nothing, the courts are not going to necessarily look favorably on those expert affidavits. And the court's language is very it's very powerful about the driver. He was under a duty to yield to the decedent. She was in the crosswalk with the walk signal. And his statement that he never saw her while being observant, I was being observant, but I didn't see her, is incredible as a matter of law. Okay? So if you have someone as your defendant or a plaintiff saying, I never saw the other person, and they didn't just drop out of the sky or they came from a blind spot, courts have held that is going to be incredible as a matter of law. A bicyclist has duties and rules of the road as well. Bicyclists also have to obey this whole sections of the vehicle and traffic law that apply to bicyclists. If you have a bicyclist, that was struck by a vehicle that violated the vehicle and traffic law, you can still win summary judgment on that case. And in your materials is a case called Kelly versus the City of New York. And it's at page, I attached the entire decision as well as the appellate briefs for both the plaintiff and the defendant in this case. At the trial court level, on a motion for summary judgment, the trial court denied the plaintiff's motion for summary judgment. The citation of the case is, it's on page 463 of your materials, and the citation is 873 New York subsecond 51. It's called Kelly and Nacht. The gentleman who died was a Dr. Nacht, and his wife was Mary Beth Kelly. They were riding on the bike path in Manhattan, and it was at night, but they were on the bike path. Miss Kelly had a light and a horn on her bicycle. Dr. Nacht did not. They're riding a tow truck owned by the City of New York. They're riding past the entrance to the impound lot. Tow truck makes a right-hand turn as they're coming towards him. Okay, so if you can picture it, they're going this way, the tow truck is coming this way, makes the right-hand turn. Strikes Dr. Nacht, sends him flying, where he strikes his head and dies a day or two later. Okay? The motion was made for summary judgment, and it's funny because it cites the Kirchgassner case in reversing the trial court's decision and granting the summary judgment motion for the plaintiff. The tow truck driver had an unobstructed view, and this is the language. He failed to obey the yield sign, and he failed to observe either the plaintiff or her decedent prior to making a right turn across the bike path and striking the decedent. With regard to the issue of comparative negligence, one of the issues was vehicle and traffic law requires bicyclists to have a horn and a light on their bike. Everyone here know that? Everyone here know that? Yeah, I know I did. Who knew that? Miss Kelly had it. The court found, well, the driver never saw Miss Kelly's light. She was right next to her husband. So what's the difference? If Dr. Nacht had a light on his bicycle, he didn't see hers, why would he have seen Dr. Nacht's? They dismissed the comparative negligence defense, rejected it, I should say, and granted the motion for summary judgment. And the thing that I always found funny was the argument by the defendants in this case, because people have to be creative, and I applaud that. Creativity is very, very important in our profession. They were trying to fault the the decedent, for his actions in trying to get out of the way. Okay? This is actually true. The court said the decedent's reaction in veering to get out of the way of the path of the truck was not an unreasonable reaction to the emergency circumstances confronting him, the emergency charge from the PJI. If you see a truck about to hit you and your natural reaction is to get out of the way, well, that's reasonable and that's accepted, and the courts aren't going to say, you know what, you were comparatively negligent because you didn't get out of the way in the best way possible, or you didn't get out of the way quick enough. You weren't Brian Stapleton, jumping out of the way of the car and not getting your legs crushed. Okay? The brief is in here for the appellant and the appellee, and there's a lot of case law on this issue in these briefs, and they're very telling as far as the language the courts are using in deciding these motions. Okay. Now, the innocent passenger in a motor vehicle. If you have a passenger in a motor vehicle in a one-car accident and the driver lost control, wasn't paying attention, was drinking, whatever, if you want to make a motion in that drinking case or you don't, it's up to you, but that's the kind of case where you as a representative of a passenger can win that motion very easily. Again, the seatbelt defense is not going to be a defense to liability. Now, if your client is fooling around in the car, joking, singing, whatever, sending text messages to the driver, doing something stupid in the car, there's going to be a defense to that case, and you're not going to necessarily win summary judgment. You may want to consider not doing it under those circumstances. And there's case law on that. If the person was doing something to distract the driver, they're comparatively negligent or possibly assumption of risk. If they get into a car with a driver they know to be intoxicated, and only the reason that driver was driving was because she was less drunk than the passenger, you're going to have a problem. I have that case, just so you know. That case actually exists, where it's just a question of who was the least drunk person ends up driving the car. You're not going to win summary judgment in those cases, okay? If it's a 2-car or 3-car accident and you have the passenger, you might win summary judgment on liability as to the defendants, but you're still going to have a full trial on liability anyway, because the apportionment has to be made by a jury. Unless it's a hit and a rear, a jury still has to make an apportionment, so you're still going to have to put the entire case in. And you put it in depending on, on the facts of the case and the circumstances. So in those circumstances, you may not want to make that motion for summary judgment. If you know, well, what am I really gaining? Well, you may start the interest clock running. That might be a good benefit. But by the same token, is it really going to be worth it necessarily if you're going to have to try the whole case anyway? Now, it's something you have to consider, and something that, it's not going to put any additional pressure, because I know if I were defending a case, I would say, listen, what are you looking at me for? He's 50% responsible too. So, okay, yeah, we're both liable, but, as to what degree, we're still going to have to try the case. So you may not want to make it in those circumstances. Okay. Now, another area where I have become more aggressive recently in making motions for summary judgment is the left turn case. Now, some people may remember, years ago, I used to hear this from adjusters, that in a left turn case, the person making the left-hand turn, 2/3 responsible, the person driving straight, 1/3 responsible. Adjusters used to say that, 2/3, 1/3. Left turn case, always 2/3, 1/3. That's not true. It's not true, especially given the language that a person driving straight has the right to anticipate that a person will obey the rules of the road and not make a left turn directly in front of them. And I've won those cases fairly regularly, and the 2 cases I was just discussing before, Kelly and Nacht, are kind of variations on that left turn case theme involving a pedestrian and a bicyclist. Now, with a left turn case involving 2 vehicles, it's something to very strongly consider. As a matter of fact, in Nassau, in 2008, a case called Marafiotti versus Reisman, it's in your materials, it was a motorcyclist was driving straight, and a car made a left turn into the path of the motorcyclist. The court granted summary judgment to the motorcyclist. How many cases have anyone ever seen where a motorcyclist gets summary judgment? I mean, that was the first one I've ever seen. I mean, unless it was a hit in the rear, it's so rare. Motorcyclists are always Evel Knievel, Hell's Angels, they get what they deserve. I mean, that's the attitude of most people, and most jurors, frankly. That case, the court basically held, the plaintiff had demonstrated a prima facie entitlement to summary judgment in violation of, the defendant violated Vehicle and Traffic Law Section 1141 when the defendant made a left turn directly into the path of plaintiff's motorcycle as the plaintiff legally proceeded into the intersection with the right-of-way. In addition, the defendant admitted never seeing the plaintiff nor the motorcycle prior to making the left turn. And that case is 2008 New York Miscellaneous Lexus 8521 Judge Brandveen in Nassau County. That's that language. They have a duty to expect that they're going to have the right-of-way and that they're going to be able to abide by that right-of-way. And the defendant's testimony, they didn't see the plaintiff prior to the accident, being incredible as a matter of law. If you can start getting those languages in preparation of your depositions and with your motions and your clients understanding these concepts, you're going to have a leg up and be able to make these motions and win them, because you're going to be able to point to precedent which says, Judge, where the defendant testified that he didn't see the plaintiff even though the plaintiff was right in front of him, that's incredible as a matter of law, and the plaintiff or the defendant, either way, had the right to expect the other side was going to obey the rules of the road, boom, you've established liability. Now they can still argue comparative, and there can still be that kind of argument made, but right now you've made out a prima facie case using the language of the courts that they've been peppering throughout, and it's also, again, I said before, in the PJI. Okay, and the other area where you cannot make motions for summary judgment, which is you can win, is vehicle and traffic law violations, stop sign cases, red light cases. If you have a clear testimony that the defendant or plaintiff ran a red light or ran a stop sign, I make those motions in all those cases, because it's the language. So you let the other side say, well, try to come up with some comparative or something. If you have a stop sign and you have a traffic control device, in your favor, make the motion. Okay. By the way, the yield language for violation of a yield sign in the PJI is more onerous and better for a plaintiff than the stop sign language. If you ever read the yield charge, it basically imposes a duty that's even higher than the stop sign charge. It's pretty fun. You guys take a look at it if you get a chance. I'm not going to repeat it here, but it's a good language, and it's something, if you have a yield case, make sure you read that PJI and you pepper your pleadings with that language. Now, talking about the fact pattern now that we have presented to us, would I be making a summary judgment motion in this case on behalf of anybody? Probably not. Probably not. The fact that these guys parked on the side of the road with their vehicles still in traffic, I think would be enough for any judge. I don't care how pro-plaintiff or how liberal they are. I don't think any judge would in their right mind look at this and say, all right, there's no culpable conduct here, at least not as a matter of law, make that decision. He would leave it up, or she would leave it up to a jury to decide. I probably wouldn't make the motion in this case. Myers dropping his cell phone, being on the cell phone, that's all good stuff. I may want to save for a jury anyway, but by and large, I don't think I would win the motion, so I probably wouldn't bother in this case. I don't really like to make a motion where, unless I'm reasonably certain I'm going to win, because it's time consuming, and I like to do work that I know is going to be more productive than wasting my time, and I also like to see my kids and not stay till 8, 9 o'clock at night. So sometimes I may not make that motion because I want to go. I don't think I have a reasonable chance to win. If I do think I have a reasonable chance to win, I'll stay till whatever time I need to stay to get it done. But I'm trying to be smart about it. Okay. Now, the last thing I want to talk about is what Robert Glick had mentioned earlier, as far as no-fault threshold motions from the plaintiff's point of view. A motion for the plaintiff winning liability doesn't have any impact on a threshold motion. If you have a hit in the rear with a bulging disc and you're the plaintiff and you say, oh, well, I'm going to win my summary judgment motion on liability. Well, Robert Glick's going to cross move on threshold and probably beat the pants off of me. Okay? So that one is not necessarily related to the other. But as a plaintiff, let's talk about how you defeat a motion for summary judgment from the threshold perspective. It starts with the preparation of the case from the get-go. Your client, first of all, has to have a real injury. Okay? The Daimler disc in this day and age is probably not going to cut it with most courts. They're really wanting to weed out these cases and get rid of them. Okay? So if you have the Daimler disc and you have a guy that is quite honestly a 60-year-old construction worker who's got a bulging disc at C4, C5, and then you see the MRI report and he's got a bulging disc at every level, up and down his back, he's got desiccation, you guys all see the language, I don't have to repeat it. If you have that kind of case, you probably shouldn't take that case from the get-go, unless you have a real doctor who's going to tell you, based on his examination, based on the limitations of the range of motion, based on the MRI reports, maybe there's EMG testing, based on some objective findings that's related to this accident, as opposed to, as Robert said, just having a normal, happy life. Okay? Unless you have that, you're going to lose that motion. Now, but if you get the client, let's say you get the 27-year-old who's got rear-ended and has a herniated disc at C4, C5, a classic whiplash type injury. Now, I'm not going to get into too much of an anatomy lesson, but a bulging disc is the material between the vertebrae where the disc bulges. It squeezes it pushes out into nerves, spinal cord, whatever. That's a bulging disc. A herniation is a hole where the fluid inside the disc is actually leaking out, increasing pressure, causing pain. They're two very different things. People oftentimes will use them synonymously, and they're not synonymous. Okay? A herniated disc that's real and related to the accident is not a minor injury. Okay? It can be a very severe injury. Anyone who's had or knows a client who's had a real one knows it can be a very debilitating and very serious injury, as opposed to a bulging disc that just occurs through the normal, my back is sore, kind of thing. All right? But if you have objective testing, and a doctor who's a real doctor who can give you an affidavit, and you believe your client, like I said, the 27-year-old with the herniated disc, you'd see the MRI report, and the rest of his cervical spine is 100% healthy. But there's a bulging disc at C4, C5 in a 27-year-old man. All right, now that's a case that you have to handle, and you have to make sure the client understands their obligations as far as getting the proper treatment, because they need it. There's therapy, stretching, there's possibly injections. There's things that can be done to help that client and alleviate the pain. By the same token, you're also setting the groundwork to defeat a motion for summary judgment in that real case, in that threshold motion. In that real case, you have the objective proof. If I had a case and Robert made a motion for me and I could show this guy's spine is 100% healthy except for that one disc, I'm very confident I'm going to beat Robert on that motion. And I know my doctor's going to say it's clearly traumatically related. Look at the rest of his spine. The rest of his spine is fine. The EMG is consistent with the radiation coming from that particular area of the spine and radiating to whatever parts of the body. The objective proof will be there, and you'll be able to defeat the motion. Now, Robert mentioned this before. Don't just attach a doctor's report, and don't attach a medical record to your motion, to your opposition papers. They better be certified. Now, what I like to do is I will have my doctor's report. I'll hopefully have had them way ahead of time, and had them exchanged a long time ago so the defendants know what's coming. They know that, you want to make this motion for me, you're going to get